So the next decision I'll talk about is the order of the Quebec Superior Court in Kitco. In this case, the taxpayer operated a business trading precious metals. This involved buying scrap metal from vendors, but selling refined bars and ingots. The purchases of scrap metal were taxable supplies, but the sales were exempt supplies. According to the tax authorities, these types of arrangements are prone to abuse, and in fact, there have been many HST and Quebec sales tax judgments dealing with these types of businesses. In 2011, Revenue Quebec reassessed the taxpayer for over $313 million in denied input tax credits and input tax refunds on the basis that it had allegedly colluded with fraudulent suppliers who were paid GST and QST by the taxpayer, but who in turn allegedly never remitted anything, whereas the taxpayer claimed ITCs and ITRs for the tax it paid. The tax case is still unresolved, but in the meantime, the taxpayer sought and obtained a CCAA arrangement and continued to operate its business. As it continued to operate, the taxpayer generated more input tax credit and refund claims, and Revenue Quebec, both acting for itself and as agent for the CRA, withheld the input tax credits to offset against the pre-CCAA debt. The taxpayer applied to the Quebec Superior Court, which has jurisdiction in bankruptcy and CCAA matters, to get the credits released. The court ordered the credits paid to the taxpayer on the basis that the provisions of the Excise Tax Act and the equivalent Quebec legislation that create deemed trusts do not apply in a bankruptcy or CCAA context. To do otherwise, the court explained, would violate the cardinal principle of keeping unsecured creditors on equal footing. Revenue Quebec is appealing this judgment to the Quebec Court of Appeal.